Hey, hey, hey! All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning and welcome to the Massachusetts Appeals Court on this Tuesday, February 4th, 2025. I'm Justice Ditkoff. To my right is Justice Han, and to my left is Justice Walsh. And we're the panel for all the cases today. We got a lot of experienced people, but not everyone, so I'll run through the basic rules here. There's a clock there that will count down the 15 minutes. When you have 90 seconds left, it'll turn yellow. When time runs out, it'll turn red and start counting up. When it's red, that isn't how much time you have left, that's how much time you're over. If the light turns red, you can finish your sentence, but please don't say anything else unless you're answering questions from one of the judges, in which case, please do complete your answer. There is no rebuttal in the Massachusetts Appeals Court. We have read your briefs. We have looked through the record. We understand the arguments. And so there's no need to give us background. You can jump right into your argument. All right, with all that having been said, I'll call the first case of the morning, Commonwealth versus Mitchell, number 24P302. Counselor, whenever you're ready.
Thank you. Catherine Essington on behalf of Marcus Mitchell. I'd like to start with the second issue in my brief. Hopefully you've all received a copy of the 16L letter that I submitted. I would argue that that case is determinative of this issue, that there simply was no evidence that Mr. Mitchell did not possess an FID card, and his statement about the license to carry is not evidence from which a rational juror could conclude otherwise. There are no questions about that. I'd like to turn to the reasonable suspicion issue, the first issue in the brief. The Commonwealth did not meet its burden below of proving that there was reasonable suspicion in order to detain Mr. Mitchell. The trial judge did not find explicitly the precise moment that that detention occurred, but it appears from his analysis that it was upon the approach to the vehicle or just after the approach and prior to the questioning, because he does analyze the factors, quote, upon approach. Mr. Mitchell agrees with that analysis. While not every questioning of a defendant is a stop, in this case you had the presence of two uniformed officers who got out of their car and approached his vehicle from either side and began questioning him about his activities that day. This was not any kind of a welfare check. This was indeed a criminal investigation and inquiry. And Article 14, as this court is well aware, provides more protection in terms of defining the moment of seizure. At any rate, the Commonwealth concludes that the detention occurred no later than the point where Mr. Mitchell was asked for his identification.
Does that timing change the analysis if we opted to, or if we saw things as the Commonwealth does?
Yeah, well, there were, yes. So obviously which position the court adopts is going to determine what the officers had actually observed at that moment. The only additional thing, additional items that they had observed at that point would be the unlit marijuana cigarette and the alleged presence of ripped baggies in the car. The Commonwealth does not articulate what crime it believes the officers had reasonable suspicion to investigate.
Are they required under the case law to identify the exact nature of the crime?
I don't know that they are, Your Honor, but I would suggest that, particularly with respect to the alleged presence of baggies, that is an important consideration, because if the crime they're investigating is something other than a drug transaction, then the baggies really adds nothing to their claimed reasonable suspicion. So I do think that is an important thing for the court to consider. I would suggest that many of the factors cited by the Commonwealth were simply normal behavior, particularly the supposed scanning around of the parking lot. This was not a quick transaction. The officer testified he watched the defendant and his companion for 20 minutes. And I would suggest to this court that when a person is in a public place like a parking lot, that it's normal behavior to sort of look up and around and notice who else is present, and that is not any kind of suspicious activity. The police officers here knew that they had not observed a drug transaction. The officer testified about having observed an exchange of money for women's shoes and large trash bags that were put originally in the trunk of Mr. Mitchell's car. So they knew it wasn't a drug transaction, and they did not have reasonable suspicion of any other kind of illegal activity. This was simply a fishing expedition. The only other factors here are basically Mr. Mitchell's alleged nervousness, that he was sweating, that fidgeting, and again, I would point this court to case law that indicates that it's not unusual for anyone to be nervous upon the approach of police officers, but particularly African American males, as Mr. Mitchell is. The presence of 2 cell phones is also not unusual. If it was 5 cell phones, maybe that would be unusual, but it's certainly not unusual for people to have a work phone and a personal phone, or an old phone and a new phone.
Can I ask you to focus your attention, just looking and mindful of the clock, on your argument about the motion to renew, the motion to suppress for racial profiling?
Yes, Your Honor.
And could you address just a couple of basic questions for me? One, can you explain to me why it wasn't waived? And secondly, why there was sufficient kind of evidence presented to the judge, if it wasn't waived, to obtain a new hearing based upon, in essence, a black person in a white town?
Yes, Your Honor. First of all, with respect to the waiver argument, I think the Commonwealth is making a really hyper-technical waiver argument here. Obviously, the issue wasn't raised by prior counsel, which is why subsequent counsel then sought to reopen the evidence or renew the motion to suppress.
So if we can explore that a little before you get to the other part of Judge Walsh's question. So it looks to me like counsel waited 11 months after Long was decided and filed the motion 2 months, less than 2 months before the trial date. I have that right?
I would accept Your Honor's representation. I don't recall off the top of my head.
So when someone waits that long and puts it at a point where it would delay the trial, why isn't it reasonable for a judge to say, in an exercise of discretion, I'm not going to hear this? Be different if you had raised it right after Long came back, when it wouldn't affect the trial, but at this point it's just delaying.
Well, I don't know that we know that it would have necessarily bumped the trial, although certainly it could have. And, you know, the trial judge did not find that delay was an issue in denying the motion to renew. He didn't cite that as a reason, so I would just suggest that we don't have enough in the record to suggest that that was a factor in his denial, or that the trial necessarily couldn't have proceeded. In terms of the sufficiency of the motion, certainly it could have been more robust. I would agree with that. But I do think it was sufficient pursuant to Long. I mean, Long does say that statistical evidence is not required. Mr. Mitchell, attorney did cite some statistics about Auburn, et cetera. And we do know that this occurred in broad daylight, so obviously the officer knew the race of Mr. Mitchell and his companion.
Well, so Long had 6 factors, and I didn't see how any of them applied. Could you walk me through how some of them apply?
There were a number of factors in Long, I agree, that just don't seem applicable at all, like the sort of the public safety factor in terms of that assumes that there was an actual traffic stop where there was no threat to public safety here at all. Obviously, Mr. Mitchell was sitting in a parked car by himself in a business parking lot. So I agree, some of the Long factors don't fit neatly in here, which is, again, why I would suggest that the motion was sufficient. I think, she did, cite the fact that the officer could clearly observe what was going on in terms of race, that he did not accept Mr. Mitchell's initial explanation, which about what he was doing, which he knew to be true because he had observed Mr. Mitchell for 20 minutes or so. I guess if the court has no further questions on that, I'd like to...
I have one more question about
Sure.
that. Let's say we think a Long motion should have been considered. What do we do now?
I think the court would then have to remand the case to the trial judge and with directions to hold a hearing on the Long motion, and then the Commonwealth would have to respond. The Commonwealth never even responded to that, other than to argue that the motion was untimely.
And on top of that, I guess one of the questions that I have still as to waiver is that this was never an issue at the original, you agree, motion to suppress, right? The
Correct.
issue of racial profiling. So it's not as if when Long came out, okay, I attempted to introduce evidence of racial profiling in my original motion to suppress, but I wasn't able to because I only had non-statistical evidence. Long comes out and changes the landscape of what defense attorneys can now present as far as acceptable kind of evidence is concerned. And so, but it wasn't even hinted at in the first motion to suppress. And so just because there's new case law, it was never argued in the first place. So walk me through why you get a second bite of the apple when you didn't bite the first time.
I think, prior to Long, there was a real feeling that these motions were just impossible to bring by defense counsel, that the hurdles, and the court addressed this in Long, that the hurdles were so high to making this claim that just numerous defense lawyers just didn't make it. So I agree with Your Honor, it certainly wasn't raised in the original motion, but I think at the time that just the legal hurdles to raising such a claim were kind of insurmountable to a lot of cases. Just briefly, my time is running out, turning to the question of intervening criminal acts. I think the court misapplied King in this case. Certainly, Mr. Mitchell, as I said, was properly charged with driving offenses and resisting arrest, but the discovery of all of the items that he was ultimately charged with occurred as a result of the illegal detention of him, not as a result of his later flight. And there was just simply no attenuation. The Commonwealth did not show any attenuation between the illegal stop and the discovery of those items.
Wasn't there a magazine clip in the trunk that wasn't discovered prior to?
Yes, but Mr. Mitchell was found not guilty of that offense. So all of the evidence that ultimately led to his convictions was prior to his
I
flight.
thought the gun hadn't been seen.
Well, there's sort of the record is unclear about that, I would argue. The trial judge, the motion judge, I'm sorry, actually found that the gun was discovered prior to the flight, and the Commonwealth disputes that. I think the officer's testimony, I think, was that he felt the magazine, but the officer did ask Mr. Mitchell if he had a license to carry, so I would suggest that they were both found before. But certainly the search of the backpack occurred prior to the flight.
So I suppose you'd agree the reckless operation, resisting arrest convictions aren't affected by any of the issues you've raised?
That's correct, Your Honor.
All right.
I see that my time is almost up. Is there any other questions? Thank you.
Thank you very much, Counselor. And we will hear from the Commonwealth.
Good morning, Your Honors. May it please the Court. Nathaniel Bodwin for the Commonwealth. I want to start with the issue raised in the 16L letter. The defendant brought up the recent Encarnacion case and said that case essentially shows that the evidence here was insufficient, but I think these claims are before this Court on different footings. What happened in Encarnacion was the Court found there was a constitutional violation. They found that the defendant's confrontation rights were violated when the CJIS employee testified that there was no LTC or FID. So the Court was analyzing whether the ammunition charge, they were analyzing it under the harmless error standard. And under that standard, it's not enough for the Commonwealth to demonstrate that there was other evidence that was sufficient to convict the defendant. And the Court looked at whether that tainted evidence that came in had any impact whatsoever on the jury's verdicts and their ultimate conclusions. In this case, it's a sufficiency claim.
We said, though, I mean, that's true. Everything you said is true, but we also said, without Dooney's testimony, the Commonwealth could not establish the elements necessary to convict the defendant of unlawful possession of ammunition.
That is correct. They do say that. And what I'm saying is, under the harmless error standard, the Commonwealth couldn't then, like the Commonwealth was able to do here, suggest there are reasonable inferences from other evidence that made the conviction, made the element sufficient. So here it's whether, in the light most favorable to the Commonwealth, could the jury have found, would it have been reasonable for the jury to find, the officer asked the defendant, do you have an LTC? I think it's reasonable for the jury to have found, when he said no, if he actually did have an FID card, he would have said, don't have that LTC, but I have the FID card.
Why would someone say that? They found you with a gun. They ask you if you have a license to the gun. Would someone really say, no, but I've got a license to the ammo inside the gun? Why would someone do that?
I think, well, I would suggest it would be if someone is in an interaction with an officer when ammunition was just found, I think it would have been reasonable to the jury to infer that the defendant would have said that. Now,
But no, let me back up for a moment
Sure.
on that. The problem with that analysis is that as generous as the sufficiency of the evidence standard is for you, you're relying upon the failure of the defendant to incriminate himself for the reasonable inference. So in other words, you think it's fair game for the jury to sit back and say, hey, he didn't testify. Hey, he didn't say he wasn't guilty or this. It's the Commonwealth's burden, not the defendant's burden, to establish the elements. And so can you walk me through what, respectfully, without the defendant saying, no, I have something over here, without, if I reject that argument,
Yeah, no.
how you get there? Because I'm having a difficult time getting there.
So I would say, is this the strongest inference in the history of inferences? No. But inferences don't have to be necessary or inescapable.
You've got the no LTC, but what's the inference even that he doesn't possess an FID? Very different than LTC. So walk me through it.
The inference would only be that the jury could have inferred that they were aware the defendant was asked for an LTC. I think it would have been reasonable for the jury to have inferred he would have mentioned.
Remember our agreement. We're not talking about this
Okay.
incriminating statement. So
Beyond that, Your Honor.
yeah.
Beyond it being a reasonable inference, I don't have any additional arguments to be made specifically about the sufficiency, if we're ignoring what you want me to ignore.
Well,
And
I want you to understand the concern I have about relying upon a sufficiency of the evidence argument of a defendant's absolute right not to incriminate himself as a reasonable inference. It seems to me to be fraught with about a substantial amount of constitutional error. But besides that, I mean, even in the practical sense of, take a different example. Take a driving a motor vehicle case, and they don't have a license, for example, to operate a 16-wheeler, right? You could say, I have a license to drive a regular car, but I don't have a TT unit. You've got an element to prove there. And without his statements, I just don't see where the jury had any evidence, let alone sufficient.
I think the Commonwealth's position would be weaker if there were no statements made by the defendant at all, if there was no response to the officer's question, but here there was a response. So I would suggest maybe that's a little bit different. And I guess moving on to the issue of the motion to suppress, I do think the judge properly found there were specific and articulable facts that supported reasonable suspicion. I don't think there's one case that is the best case, but I did cite to a series of cases that dealt with each of the factors that were present in this case. In terms of the motion to renew, I do believe the argument is waived, and I do believe that the motion judge, Judge Ritter, did say in his margin decision, he did say that substantial justice didn't require the motion to be allowed, but he also did specifically say he did not find the defendant made a sufficient showing of racial profiling. So to the question of what to do if you find there was there should have been more analysis as to the long motion, I think the judge did actually make a finding that what the defendant presented was not sufficient in terms of a long motion.
So if we find no probable cause, but we agree with you generally on intervening act and with the judge, is there any argument for the possession of cocaine count?
I think what the Coleman case says is that intervening criminal acts, well, I think I'm answering incorrect way. Can you ask your question again, Your Honor?
Well, so I'll put my cards on the table. So the Pat Frisk finds cocaine
Yes.
in the defendant's pocket. And it seems to me that evidence goes to the possession of cocaine conviction. And therefore, even if the intervening act works, if there's a problem with that Pat Frisk, the possession with cocaine conviction goes. Am I wrong on that?
Well, the intervening acts obviously happened after that, so I don't see how, and of course the Commonwealth's position is nothing should be excluded here.
No, I get that, but I'm
Yeah.
trying to explore. So we say, everything found after the intervening act is fine. comes in, all the stuff that was seized doesn't get suppressed. But we have to still suppress the stuff that was seized in the pat frisk, right?
So in terms of the cocaine, that was, the defendant had left the vehicle, basically offered, he mentioned, oh, I'm just buying women's shoes, want me to show you the shoes? He gets out of the car. The defendant is continuously putting his hands in his pockets. The officer says, if you keep doing that, I'm going to have to search you. And he was essentially invited by the defendant. The defendant consented to that search. So I don't see how there is any impropriety in the officer searching the defendant after he essentially consented to do so.
You don't think the consented pat frisk is a product of the seizure of his person?
Well, he was seized at that time, but I think the analysis is different because he essentially consented and invited the officer to search him. And if there are no further questions, the Commonwealth can rest on its brief. Thank you very much.
All right, well, thank you both. It's an interesting case, and briefing and argument was very helpful. All right, I'll call the second case, number 24P78, Commonwealth versus Regan. Whenever you're ready, Counselor.
Good morning, Your Honors. Peter Brewer from Great Barrington, and may it please the Court. I'm here representing William Regan. I start with the proposition that the bar, or the threshold, for the self-defense argument, the self-defense instruction, and in this case, indeed, I would say a question to the jury on self-defense is a low threshold. It's a low bar. And the case law is pretty consistent in confirming that, remarkably, no matter how incredible, I believe that word is used in one of the cases, no matter how incredible the evidence that defendant would use to support the self-defense, it should nevertheless be considered by the court. And the court is reminded, the trial court's reminded to err on the side of the defendant, to interpret everything in light of the favorable to the defendant, without doing any sort of balancing or credibility. Any evidence that would support it should be considered.
But does the court ignore any undisputed evidence?
No. And if I were to, I mean, the video, in a sense, is unsupported.
Right. Sorry, unsupported? Or
Undisputed.
No. The video it was stipulated to and put into evidence, and it was agreed that it was a video of this incident. The court isn't called upon to ignore that. Did I phrase your question right?
Yes, thank you.
The court certainly wouldn't ignore it, but you know, that's almost the problem here, to use the word ignore, because here the trial court, respectfully, she just became obsessed with that video to the point of, I have to say, again, respectfully, almost closing her mind to anything that came further. And of course, I remind the court that the video had no audio. It was silent, so it had to be considered in light of additional evidence right from the start, things that were being said by the individuals. But what troubles me about the court's sort of, looking at the video and ending it there is that she actually used the word facts. These are the facts that apply here. And she had a debate with defense attorney where he said, well, Your Honor, respectfully, I don't agree with your assessment of the facts. But she said that the judge said, that's it. The facts are the facts here. She went on to say, your client is the first aggressor. He ran the man down. I don't see self-defense here. You have to earn it, and I don't see it. Most troubling, I would see from the trial court's perspective and her assessment of the case is the quote, this decision was made prior to the trial starting. So, and it's interesting, Commonwealth makes a point in a footnote, I believe, saying that this comment indicated that the court was sort of considering the thing straight through. That wording, to me, almost says the opposite. This decision was made prior to the trial. This is no surprise, defense counsel. You knew this in the beginning. And again, that's before evidence was developed. You know, one of the cases that I find interestingly analogous in reviewing the cases is this one, I believe it's Santos. I think it's the case where the victim was shot in a bathtub. And there were two expert analysis done by the Commonwealth, both of which determined, as I recall, that the victim was standing in the bathtub. The defendant was probably 3 or 4 feet away, pointing at the victim and shooting him 3 times. And so, you know, you have these two experts that are describing the scene that way. If I'm the judge there, I'm thinking, wow, you know, should I stop there? Well, in that case, the judge did not allow self-defense. Remarkably, the Commonwealth said that the court was compelled to consider the testimony of a girlfriend. In this case, the girlfriend who had been in the bathroom, she claimed to observe there was a struggle over the gun, which resulted in the victim being shot. Now, it seems somewhat incredible, that might be the case where that word is used, that the girlfriend's testimony of a struggle over the gun could somehow result in 3 bullets into the guy from 3 or 4 feet away. Nevertheless, that case ruled on the self-defense. I think a couple of the other cases that compel me to make this argument and find error here is Ortega. And Ortega, which I cited in the brief, that kind of makes the point. Commonwealth also argues this point, appropriately so, that when an incident like this occurs on the street, that's more supportive of an argument that the defendant could have turned around and fled. But the Ortega case, you know, makes clear, similar to the argument made by defense and defense counsel here, that case makes clear that there's no hard and fast rule. Again, all the evidence has to be considered. And in that case, the court said, you know, a defendant can't be required to turn around, walk the other way, and face the potential of a bullet in his back.
So can I ask you a question?
Thank you.
Do you agree that the judge has some discretion in determining whether sufficient evidence has been presented to entitle a self-defense instruction?
Yes, Your Honor.
Okay. Can you give me an example in which you agree that there is insufficient evidence presented to entitle the self-defense instruction? So in these days of Ring cameras everywhere.
Right. Good point, Your Honor. I guess in a general example, if you will, I suppose someone's filming something with their own phone. There's audio, there's visual. You can hear the language between the parties. You can interpret whether or not the defendant had a realistic expectation of injury by the very words. And then you might take that a step further where the testimony, perhaps the defendant himself were he to take the stand, were to testify contrary to the words that were spoken.
So the judge would be, it would be fair game for the judge to consider those factual findings.
I'm sorry, Your Honor. Again?
The judge would be fair game for the judge to consider those facts, the tone, the language, the body, posturing.
Yes, Your Honor. I mean, I can't deny that there are circumstances where a court has the discretion to determine whether or not self-defense applies. I think the difference here, if I may distinguish, unless I didn't answer your question,
but
I think to distinguish here is you have a video, that's fine, and you have the court, I believe, just getting stuck on it right from the beginning, notwithstanding the fact that it's audio, without audio. Another thing that concerns me here, toward the end of my brief, Commonwealth picks up on this also, and we'll discuss it, is this notion of my client being denied to testify that is, as you know, these two people knew each other. They have, in fact, perhaps been friends or at least colleagues. And my client was denied to testify that occasionally, or perhaps always, the victim, Mr. Yankowski, carried a knife with him. And I think that's very significant because it would certainly go to his state of mind. It would certainly go to his decision to drive forward or turn around, again, putting himself at risk. And interestingly, the Commonwealth, in its stated argument toward the end on this issue, says, and this is in the context of, did the defendant in this particular circumstance use more or less force than was necessary? Because that's the standard when you use what could be considered, dangerous force. And the Commonwealth argues that, well, yeah, because it used a motorbike, drove at this guy, who was, and the wording is, an unarmed pedestrian. So I find it interesting and a little circular that the Commonwealth relies on this notion of being unarmed. Well, the only reason he was, well, I shouldn't say the only reason, but a big reason he was determined to be unarmed was because the defendant was not allowed to testify that he does carry a knife with him. And it was kind of even quibbled down a little more, too, because the defendant was allowed to say that I thought he had something in his hand, but
Couldn't say, he was unable to say what it was, correct?
couldn't say what it was.
Right.
And the defendant, thank you, Anna, because the defendant did say I couldn't see exactly what it was. But it was sort of kind of, narrowed down to this notion of I thought he had something in his hand. And I think that a reasonable fear, there is an instruction that a defendant in using self-defense can make a quick decision based on the circumstances. And I think that the knife was...
So why
thank you, Your Honor, excuse me.
why couldn't your client drive away on the other side of the street or drive away on the side of the street he was traveling without going on the sidewalk? It looked like both were available methods of retreat. Why weren't they?
And if I may ask, Your Honor, specifically which instance, because there sort of are two.
The guy runs up, threatens him, and then why at that point can't he drive off either on the other lane or drive off in the lane he's traveling on but without going on the sidewalk?
Your Honor, I think to some extent perhaps a concession is called for there. What would have been the better approach? And so, it certainly wouldn't even be here if he'd done that. And in terms of what might be appropriate, these instances between victims, complainants, and defendants happen pretty quickly. But I think, an intellectual concession would be that it would have been the preferable approach.
Isn't that required, though? Is
sorry, Your
it not required that you take all reasonable means to retreat from that threat?
Yes, Your Honor, and of course the trial court makes that point, but I have to take it a step further and say the following. The facts as they came in were, according to Yankowski, the complainant, he never threatened the guy at all when he first ran out to him. He just said, get out of here, I don't like you, I don't want you around here. Whereas the defendant said that he somehow challenged him. So if you take on its face value the fact that Mr. Yankowski was right, that he didn't really threaten him, there's really I would say there's no reason that he couldn't turn around and, talk to Mr. Yankowski, because the initial interaction hadn't been a threat. So you can take the facts either way there. But I do think, more specifically in response, Your Honor, I think that the second confrontation has to be addressed separately. In other words, these were two instances. Something happened in the street when Mr. Yankowski ran out, but then he comes around, there's a pause, he stops there, something's happening there. From the defendant's perspective, he's coming toward him with something in his hand. And from the defendant's perspective, he's yelling, I've got you now. And now the defendant's in this situation with a wall here and a traveled way here. Actually, I note, Your Honor, on page 8, I described parked cars there, which there weren't, and I always want to correct any sort of factual recitation.
I don't get why an empty travel lane is a barrier. If he can just go on the empty travel lane, why isn't that an available retreat?
I'm sorry, which travel lane was empty, Your Honor?
There's no, there's a whole lane on the way in, the way that he was traveling before, that's empty when he's
You mean
traveling
going
down
the other way?
No, the way he was going before, but there's still, the whole area where cars could park is empty. He could travel through that.
Forgive me, Your Honor, I don't recall it as a travel lane, but I defer to your interpretation of the video. But again, you're talking about the first instance. He could have just gone into that lane. I recall it to be a travel lane with traffic on it. But does this go to Her Honor's question that he could have just either gone straight or turned around? I think that would have been the better approach, but forgive me if I don't understand your question.
I'm just wondering why, even when the victim starts approaching the defendant on the sidewalk, he can't just go out into the road and drive away.
Oh, I think at that point, Your Honor, my recollection, correcting my own recitation about parked cars, is the travel lane's pretty close. I don't remember it at all being indicative of a two-lane thing. And I think the cars that are traveling, so if he's facing Mr. Yankowski, who's yelling at him, coming towards him, he's got cars traveling here, and he's got the wall over here. I would suggest it's pretty tight. I don't think it was a lane to necessarily travel in. But again, that's kind of part of the facts, and I appreciate the court's question. Let's see, I covered some of the key points. Were there any other questions?
No, thank you.
I thank you all very much.
Thank you, Counselor.
Thank you.
We'll hear from the Commonwealth now.
Good morning. May it please the court, Emily Jamalowitz for the Commonwealth. Excuse me. The Commonwealth is asking the court to affirm the defendant's conviction because there was no view of the evidence at trial that would have entitled the defendant to a self-defense instruction and therefore no error. The defendant is only entitled to a self-defense instruction if the evidence in the light most favorable to him raises at least a reasonable doubt that the prerequisites of self-defense were present. And I would argue that in this case, the defendant failed to do so. First, ultimately, there was no evidence that the defendant tried to escape from that second confrontation on the sidewalk where force ultimately was used. And there was also no evidence at trial that he was unable to escape from that area without resorting to force. I would suggest the defendant's testimony is essentially that he drove onto the sidewalk after the initial confrontation in the street, during which no force was used. When he got onto the sidewalk, the victim ran up to him saying, quote, "I got you now," ran up to the scooter, hit the handlebars, and sat down. There was no evidence that the defendant tried to turn around, that he tried to take advantage of the multiple escape routes that I would argue were very clearly available to him at that point. I would suggest the video evidence makes it quite clear there were, in fact, multiple avenues of escape available. And I would also just note that the defendant was on a motor vehicle at all times during this encounter, and so presumably had the ability to drive away faster than the victim could ever pursue him on foot.
What do you think of your friend's argument that we should ignore the first confrontation and assess it as if he were just having a conversation with the victim and then the victim attacked him on the sidewalk?
So I think regardless of what happened in the street, it doesn't really change the defendant's obligation to retreat from force once he gets onto the sidewalk. Whether or not it was a threat in the street or whether it was simply a friendly conversation, he wasn't supposed to be on the sidewalk at all. He was on a motor vehicle. So I think at most, anything that happened in the street, at worst or at best for the defendant, is a threat to kill him. That perhaps goes to his actual fear of the victim at that point, but I don't really think it alters his duty to retreat once he then puts himself up onto the sidewalk with the victim. Does that answer your question?
Sure.
If there's no other questions on the duty to retreat, I would just move on briefly to the other area I would suggest the defendant's claim is insufficient. but there was no evidence at trial that the amount of force he used against the victim was at all proportional or reasonable under the circumstances. There was ultimately no evidence that the victim had a weapon. I acknowledge that the defendant wanted to say at trial that the victim always carried a penknife, but even that is not evidence that the victim had a weapon on that day. He was, in fact, explicitly given the opportunity to say, yes, I saw a knife, but he was not able to testify to that. There certainly was no evidence he had a weapon, let alone a firearm or some kind of deadly weapon that would permit the defendant under those circumstances to use, again, I would emphasize, a motor vehicle against a person.
Would you agree that if the defendant reasonably but incorrectly believed the victim to have a weapon, that he could do whatever is reasonable if his belief was true?
So I think the case law is clear that if a defendant's if his belief is reasonable, even if it's mistaken, he may still be entitled to use force under those circumstances. And ultimately, that may have been a question for a fact finder. I do think that this kind of area of the self-defense test is a little bit different in that the force still needs to be proportional. I'm not really sure there was any evidence that the defendant believed the victim to be heavily armed and dangerous such that he would be allowed to use his motor scooter in this way. Because the force still needs to be proportional. And I would suggest that wasn't the case here. Particularly because the other aspect of this is that there really is very little evidence the victim used any force at all against him. I think everyone was largely in agreement there was no sort of physical confrontation in the street, and then on the sidewalk, at the most, the victim hit the handlebars of the scooter, and I believe the testimony was that he tried to put his hands on the defendant, but ultimately there was no force used against the defendant's person, which again I would suggest does not give rise to any basis to use this amount of force against the victim. So I am happy to address any of the more minor points in the brief. Otherwise, if there's no further questions, I would rest on my brief.
All right, thank you, Counselor. Counselor, the computer's telling me this is your first time here?
It is, yes.
Well, congratulations. You'll rest of your life. You'll be an appellate attorney. We hope to see you more often. I remember my first argument 24 years ago, and I didn't go as long as you did. So.
Oh, perfect. Thank you very much.
Thank you both. All right, I'll call the third case, number 24P 430, Commonwealth versus Andrews. Maybe we don't have that case. Are we missing the?
Here, Your Honor, I didn't hear the case.
I'm looking for Attorney Kidd and Attorney Fishman.
Attorney Fishman?
Yes. Okay. I thought I saw you guys. Wondered whether I had forgotten what you looked like. Not a problem. Let's just give your friend a second to get set up.
Okay.
As I was saying, 24P 430, Commonwealth versus Andrews. Counselor, whenever you're ready.
May it please the Court. Your Honors, this is an appeal from a judgment of conviction, second-degree murder, and in order, it's also a consolidated appeal from an order denying defendant's motion to reduce the verdict from murder to voluntary manslaughter. I have a number of arguments to press on appeal. Many are related to the conviction, and of course, and I will also argue for regarding the denial of the motion to reduce the verdict. Regarding the judgment of conviction, there are a number of areas that demand a new trial. One, of course, is the juror who was seated. That juror should not have been seated. I grant you that the trial counsel did not make a for cause or a peremptory motion, a peremptory strike against that juror. But the juror should not have been seated. That was a manifestly unreasonable dereliction of duty. Or the court should have stepped in and struck the juror. I will remind the court that the juror had clear difficulty according the defendant his presumption of innocence.
Well, the juror said that initially, but then the judge explored that a little further, and both the judge and trial counsel were obviously present to hear what and how the juror responded. And the juror was unequivocal, at least on our transcript, about the juror's ability to put aside his initial response and his or her initial response, correct? Don't we defer to the assessment on the ground of what the sincerity and credibility of that representation are?
I would submit, Your Honor, that what the juror said at the get-go was disqualifying. The juror said, if you bear with me, the juror said, the question, the court asked, if James Andrews does not testify, would you hold that against him? The juror, no, but I would rather see someone testify if they believe they're innocent. Then the trial counsel asked, now the fact that Mr. Andrews has been charged with a crime, simply charged, does that make you think, well, he must have done something? That makes you think he must have done something, yes. I don't think a juror like that should be allowed to sit in any courtroom, particularly in a criminal trial. And I would go further to say this was a close case certainly regarding whether there should have been a verdict of voluntary manslaughter. So it wasn't a situation where the evidence was overwhelming, although I don't know that would matter in a circumstance like this.
Could I ask you about that since time is short, and I'm sorry to cut you off on the juror issue. Can we get into talking a little bit about your self-defense and mitigation arguments? Specifically, can we start with your thinking on how the Castle law applies in this particular case?
Yes, Your Honor. So regarding the Castle law, as Your Honors are well aware, the question is whether there's, taking the evidence from the light most favorable to the defendant, whether there's any evidence to support a Castle law instruction. And I would submit in this case there was evidence to support a Castle law instruction. It's undisputed that the decedent came into the defendant's sleeping area and tore down a privacy curtain and destroyed his laptop computer with a metal baton or club. All of this occurred before sunrise. These are the undisputed facts. It's unclear where the homicide occurred. That's a jury question.
Why is the decedent's presence in said dwelling unlawful?
The Commonwealth argues on appeal, I guess, in its responding brief, the Commonwealth says the decedent was an invitee. There's no evidence to support that whatsoever. The record is clear as day that he bursts into the room, tears down the curtain, and destroys the laptop computer with a metal baton or club. Even if there were an argument.
Why is his presence unlawful? I always thought the people in my house can lawfully go in any room once I let them in my house that they want to.
Your Honor, this...
Lawfully, I mean.
I would submit that this is different from your house. This is a shared residence where a lot of people have their own rooms. The defendant has his own sleeping area, which was, I'll just say that the case law and the Castle law there's no case saying that just because you have curtains demarcating your room doesn't mean that you aren't accorded the protection of the Castle law.
What's the case that says that that a bedroom in a shared apartment is subject to unlawful entry by other occupants of the same apartment?
Could you repeat your question, Your Honor?
Sure. Can you tell me what, and you may have one that I'm just not remembering, but what is the case that says that entry by one occupant of a shared apartment into the bedroom of another occupant of that apartment is not lawful?
Well, I can't cite a case to you on the issue. I could certainly dig into the issue. I imagine I dug into it as I was briefing. But as Your Honor is well aware, that the terminology of the castle law is somewhat broad. It says occupant of a dwelling.
Right.
Well, by all accounts, Mr. Andrews was an occupant of a dwelling.
How is dwelling used in that way in other parts of our law? Dwelling's not defined in the statute, right?
Well, the whole point of the castle law was to abrogate the common law rule. And so it comes, the reason we call it the castle law, of course, is it comes from the old English saying that a man's home is his castle. So it cannot be that just the protection of the castle law is only accorded to someone who, as I make the point in the brief, with 4 perfectly appointed walls and this is a shared dwelling situation. It's undisputed.
But it could certainly not protect you among other family members who are living with you in the same dwelling, right?
First of all, Your Honor, the term family member is loaded. I don't know what to make of the relationships here. But just to finish up with regard to the castle law, because it's not the meat and potatoes of why I'm here today. But there's no proof that the decedent was an invitee. The Commonwealth makes a noise in their brief about that the castle law.
I thought he was the owner's father.
He is the brother of the owner, or it's unclear to me. I don't know.
Is there evidence he was trespassing in the apartment building?
When Your Honor, the question is whether he was invited into the defendant's room, and he wasn't. Moving on from the castle law area, again, the undisputed facts are that the decedent came into the defendant's sleeping area before sunrise. The defendant had just been watching pornography literally a minute ago. And he tears down the privacy curtain, smashes his laptop computer, and so the question the question was whether, under these circumstances, these are undisputed circumstances, whether the Superior Court, whether it was unreasonable for the Superior Court to deny the motion for the reduced verdict. I don't know of any other circumstance, I looked, where a second-degree murder verdict was with a similar fact pattern. By all accounts, the defendant was obnoxious. He's playing music 5 in the morning or watching pornography 5 in the morning. It wasn't the first time he'd been behaving this way. Yet, that doesn't defeat that this is a sort of a voluntary manslaughter type of circumstances. I would go on to say, Your Honors, that the court made 2 mistakes. The Superior Court made 2 mistakes in denying the motion to reduce the verdict. One mistake the Superior Court made is said, the Superior Court's analysis was, the decedent was in retreat. Well, that may bear on the issue of whether there was excessive use of force, whether there was excessive use of force in self-defense. It may bear on the issue of sudden combat. But it doesn't bear on the issue of whether there was reasonable provocation. There's absolutely no indication there is anything but a negligible cooling period here of a second or 2 or 3 or 4.
Even if we accept that, though, is it not required that there be an objective showing that the response that the defendant made to the provocation, that a reasonable person would have responded in the same way? Is that correct?
Right. There's my understanding as well, Your Honor, is that there's 2 aspects of this. We asked whether the defendant was acting under a heat of passion on unreasonable provocation, and whether a reasonable person would have acted similarly. I would suggest, Your Honor, that when you are you are intruded upon, burst in upon at 5 in the morning, you're engaged in pretty private activity, and your privacy curtain is torn down and your property is destroyed. The laptop computer, by the way, I don't think there's any dispute, it was on the bed. I think it's reasonable to infer, I don't think I'm speculating here, that it's a laptop computer. It's probably on or near the
But that's not in the
defendant.
light most favorable to the Commonwealth, right? Which is that where you're, maybe I'm turning back to your
Not sure.
sufficiency question.
Yeah, on the sufficiency issue, you're right, Your Honor, but on a motion to reduce the verdict, I think it's from the totality of the weight of the evidence.
Okay,
And
but
the
there's
weight
no
of the-
evidence either way about where that computer physically was let me put it this way, there's no evidence that the computer was on your client's body or touching your client in any way, correct?
There's no evidence of that.
Okay.
But again, I think it's not an unfair inference.
And there's no evidence that your client was physically assaulted, correct?
Right, Your Honor. I do want to go back to some of the issues regarding the conviction. One is the prosecutor's opening and closing arguments, I think, are well over the top. I understand that this court and the SJC give the prosecutors fairly wide berth on closing argument, but I think this one was beyond the pale. There's sort of a biblical undertone of like, no good deed goes unpunished here. In my brief, in a footnote, I explain this whole taken in mantra that the prosecutor engages in. The prosecutor says, let me find it for your honors.
I think I know what you're talking about, but I'm not totally clear on why that's not a reasonable argument based on what the evidence in the case was.
Because, Your Honor, the prosecutor, at that point, the prosecutor is not arguing the facts as they apply to the charges. That's all this taken in business is really about that. Look at the lady of the house had taken him in. She had done a kindness, and she extended him a kindness. And look what he did. He relapsed into drug addiction. He's watching porn. He's being obnoxious. He hacks up and slices her brother, et cetera, et cetera. I think within the context of, I think if Your Honors revisit the opening argument and particularly the closing argument, I couldn't fit the whole thing in the brief. I'm hopeful the court will see that it was beyond the pale. Let me just see if there's one more area I'd like to cover here. The drugs. I will just say that the Superior Court neglected to address the issue of drugs here. This is, as the SJC has done in many of those areas where it reduces the verdict on 33E, drugs is an issue. And the decedent had a very high amount of opiates in his bloodstream and cocaine. And there's evidence that the defendant had relapsed into drug addiction. He's behaving strangely. So the Superior Court didn't take that into account in its reasoning, in its denial of the motion to reduce the verdict. So that's yet another reason why I think that order was clearly unreasonable and abuse of discretion. If the court has no other questions, I'll rest on the briefs.
All right. Thank you very much.
Thank you.
We'll hear from the Commonwealth.
Good morning, Your
I would
Honors.
like to suggest that at some point we'd like to hear about the photo of the weapon issue. We'd like to hear about the photo of the weapon issue. You don't have to start with that, but make sure you don't
Okay.
overlook it entirely.
I'll start with that then. Just give me 1 minute. Yes, so as the court knows, the Commonwealth introduced a photograph of a knife, which I have included in our brief in the record appendix. And that knife was seen by Samantha Sace, who was apparently the defendant's friend. She saw him, I guess, apparently holding that knife
Was
about
it-
a week before the murder.
Was it that specific knife that she saw?
It was not the murder weapon. She saw it, that's correct. I may have misspoken. Samantha Sace saw him holding, the defendant holding a knife a week before the murder. And she described that knife. And I believe she said it was 7 inches, may have been 7 inches long. And then, so we have evidence in this case that the defendant wielded a knife in the attack. We have a witness describing the defendant holding a silver knife. I think she said it was curved, it was 12 inches long with a 7 or 8 inch long blade. There's a line of cases, as the court knows, that says that the government is allowed to introduce into evidence a facsimile or a representation of a weapon for the purposes of showing that the defendant had access to the weapon that was used. In this particular case, the defendant says it was pure shock value that this photograph was introduced into evidence. Just as an aside, there wouldn't have been any shock to the jury seeing that photograph. I mean, the evidence was that this victim was essentially gutted. I mean, he was, his heart was outside of his chest when someone was trying to give him resuscitation. So the jury knew that. The purpose of the knife, as I said, was to show that he had access to that weapon. And the government never represented, and the prosecutor never represented to the jury that it was the same weapon. It was also relevant to show...
I'm not sure I understand why, in this case, where it's not a joint venture, it matters that the defendant has access to weapons that aren't the weapons used in the attack.
We're not saying it wasn't the weapon used. It's the type of weapon used. It was a knife that was used, and it could have been the weapon from the witness's descriptions. But he...
But if we're to accept that argument, then police can go into every kitchen and take a photograph of every knife, and it could have been any one of these, or it could have been another one, or in cases in which a defendant is charged with firing a gun, but police never recover the gun. Would you introduce a picture of what a gun looks like that possibly he's carried before for the jury to consider?
Well, I understand that, yes. I don't have them handy, but there are cases I understand where we're not talking, first of all, we're not talking about a kitchen knife. We're talking about the defendant actually holding a weapon in his hand and displaying it to a friend. So I believe that there are cases where there were photographs of a defendant holding a gun introduced to evidence to show that he had access to guns, but I don't have them handy. But I understand the concern, that the slippery slope concern is that you don't want, you don't want this to go too far, and that the jury could be prejudiced by this type of information. I think that even if the court, though, found that this was improper, given all the evidence, I don't think that it made any difference in the jury verdict. I mean, like I said, it was a gruesome murder. Clearly, the person was stabbed many times, 7 times. Cut right through his heart and through his sternum. So there was no question that the defendant essentially, attacked the victim viciously. So the fact that some knife that was introduced, a picture of this knife that was not the knife, or may not have been the knife that was used, was introduced, didn't create any error, any prejudicial error in my regard. If I've answered that question, okay. I want to go back. I want to start with the counsel's argument regarding the jury, and regarding closing and opening arguments. The Commonwealth vehemently takes issue with the defense counsel's characterization of the opening and closing arguments. This was not. These prosecutors, if you actually read the openings and closings transcripts, they did not make this a case about no good deed goes unpunished. They did not link the defendant's, the invitation of the defendant to be a guest staying free at this house with his ingratitude. There was nothing like that. What they did is they went through the facts, and the facts were that this defendant had no place to stay. He stayed in this woman's house, who was one of, I believe, a relative. He stayed in this common area, and he was asked to behave himself, and he didn't behave himself, and that led to him being asked to leave, which led to him, we argued in our closing argument, to being upset about that, which led to him playing music at 5 a.m. in the morning 2 days before he was supposed to get out, because he was given a number of days to leave, and 2 days before he's supposed to leave, he's blaring this music now. Those were the facts, and that chronology of events, the fact that he was invited to stay and he abused his privilege, so to speak, was relevant because it was relevant to his motive to be angry that now he has to leave. Now he's got to leave. He's got 2 days to leave. And what does he do? Not only does he play his music, he's asked to, at 5 o'clock in the morning, he's asked to turn it down 4 or 5 times by this young woman who had a baby in the house, and he not only does he not turn it down, he plays it louder. So all of this chronology plays into the defendant's state of mind and motive at the time, to be argued by our prosecutor that he was angry. But to say that one was linked to the other, I urge you, if you have any doubt, read the transcript. I respectfully suggest the counsel's portrayal is highly inaccurate. He picks out certain things that are said, and he's throughout the closing.
I assure you, we've read the arguments through.
Okay, maybe
Absolutely.
I am beating the dead horse. If I would like to talk about, well, I'll talk about anything else that your honors want me to talk about.
Whatever you think you'd like to talk about. We
wanted
wanted for sure to talk about the photo, and you talked about that.
Yes.
May I actually ask one question on this? The cooling off period argument that your friend makes has force, where if we get to the question of, or when we get to the question of mitigation, the argument that there was a reasonable cooling off period between the time that the victim entered the area that the defendant was living in and the time that the stabbing took place. The time period was very, very short, right? Can you tell me what your strongest argument is that was enough for a reasonable cooling off period?
Well, he had to take the time to locate the machete inside of his room, and the defendant was already in the hall at that point, at some point when he was in his room. So there was some amount of time for cooling off. I wouldn't say that is the strongest argument that I have against the mitigation. There's much more compelling arguments against that. First of all, there's no authority, and counsel doesn't cite any, to suggest that destroying somebody's property constitutes reasonable provocation to justify someone killing somebody. And as I said, the case law actually indicates, what it indicates is Rhodes and the other case there, it's Rhodes and Yat Fong NG, however you say that. Both of those say that there has to be some sort of a threat of violence for there to be reasonable provocation. And as the court noted, there was no evidence of any threat, physical threat to the defendant himself, and all the forensic evidence pointed to the defendant as being the aggressor. All of the victim's blood was on the knife that killed him. There was no scratch, not a scratch on the defendant indicating there was any kind of struggle. All of the evidence pointed to that. The other thing I would say here is that, as in Commonwealth, the defendant pointed this out in his brief, it looks like the killing didn't even occur in the room. The evidence from the witnesses was that the killing occurred in a common hallway. Oh, so that's a different argument. But in any case, that's the law. And the other thing I would say is it talks about what a reasonable person would do in these circumstances, right? That's what it says. Would a reasonable person be overcome with such emotion that his capacity for whatever it is, capacity for restraint is overcome? And here, what does the reasonable person do? A reasonable person in that situation having played this music at 5 o'clock in the morning, not turning it down, trying to essentially to provoke people to react is what he was trying to do. A reasonable person, if somebody barged in and destroyed his computer, a reasonable person wouldn't be filled with justifiable outrage and surprise. He could not have been surprised at this reaction, right? Or I should say a reasonable person, right, could not.
Well, I mean, surprised at a reaction. I think this particular reaction would be surprising.
Correct, correct. So, yes, somebody's going to, he figures, a reasonable person would say, somebody's going to come in and yell at me, right? Yeah, exactly.
Maybe even take the computer, but not smash it with a baton.
Correct, correct.
When you talk about the calming down period of time, and I understand your argument that regardless that the force used was not a reasonable force to the response of smashing the computer, but is it undisputed that the victim had the wherewithal to say calm down to the defendant?
He did say that according to one of the witnesses.
So there was time in which the victim was able to try to persuade the defendant to calm down.
Correct, correct. So that's some evidence of that there. We have 3 minutes. I don't know if there's anything else I wanted to address unless the court has other questions.
All right, well, thank you both. These murder cases are always tough, and it was very helpful, the briefing and argument that we received today. Thank you both. All right, I'll call the next case, 24P 550, adoption of Brianna. That's a pseudonym, by the way. Before we start, I know you all know this, but just to be clear, it's an impounded case. We're not going to use names. We're going to say mother. You can say Brianna because we've already assigned a pseudonym for the child, but it's Brianna or child, not anyone's real names. I understand that you're splitting this 10-5. Is that right? All right. So we'll hear for counsel. Whenever you're ready, counsel.
One second, Your Honor. Excuse me while I get my glasses.
Yeah, sure.
Good morning, Your Honors. May it please the Court. Steve Rosenthal, representing the appellant mother. Mother is asking this Court to vacate the order of TPR and to remand the case to the trial court with instructions to allow sufficient time for DCF to evaluate mother's needs, her mental health needs, and to provide adequate services tailored to those needs before a new trial takes place. Our position is even if mother was deemed to be unfit at the time of the second trial, the fact remains that DCF did not establish its burden of proving that her unfitness would continue indefinitely because DCF did not exercise or provide reasonable accommodations and did not use reasonable care in trying to reunite this family. If I may, I'd like to read from Justice Ditkoff's second footnote in his dissent in adoption of Darlene.
I wouldn't waste your time because I've read it and reread it several times.
That's nice to hear.
So I hear you on that.
Well, the point is...
Talk to me for a moment about, so your argument isn't reasonable accommodations and therefore best interests of Brianna, your argument is reasonable accommodations, therefore no, and when I say that with all due respect to my colleague of don't bother, because it has force, and it's here, and it's underlined, and it's red. So we have 15 minutes to talk about why you're correct. And so your argument is unfitness and the permanency of the unfitness as it relates to reasonable accommodations, correct?
Well, the permanent, whether
Indefinite
whether
nature,
DCF provided reasonable accommodations or made reasonable efforts in
Not
this
connected
case.
to the best interests of Brianna.
Well, our position is that it's not in the best interest of Brianna, a child, to terminate and to limit the visits as the trial court did in this case.
But if I understood your argument, I just want to make sure I understand it correctly, that you're challenging the determination of parental unfitness first, because the failure by the department to provide reasonable accommodations for mom's mental health, and thereby the judge's finding is an error that unfitness would be permanent.
Correct.
Indefinite, okay. And so what more, and accepting the fact that no meeting occurred, an ADA meeting per the 2022 policy that the department has, when an individual isn't taking medication per the plan, and an individual isn't going to counseling to get better, what more? So I'm not dismissing if there's a failure to make reasonable efforts, but what would it have mattered?
Well, here's the problem.
Right.
Sorry, I won't reread Justice
if you want
Ditkoff's
to.
comments to you, but 4 years ago, he's saying, I'm confident that DCF will scrupulously observe its obligations under the disability policy that was created pursuant to its consent agreement with the DOJ. And it hasn't done that. In fact, their standard operating procedure, as testified at trial, was to provide accommodations only if a parent asks for them. Moreover, courts in this Commonwealth have required parents to identify services that DCF should have provided, which I think is what you're asking me to do now. And as recently as the adoption of Joan case, the court said, well, we think that the argument of reasonable accommodations fails because mother didn't suggest what could have been done. Well, if there was ever a case of someone who was not capable of asking for what was in her best interest and what would help her reunite with her child, this is it. DCF knew from day one that this woman had serious psychological issues. And in fact, I'll refer the court to volume 1 of the trial exhibits, page 54. The court clinic did an evaluation, and in their report dated February 13, 2018, nearly 7 years ago, their very first recommendation was to conduct a psychiatric medication evaluation. Okay, that, here we are 7 years later, that has never been done. Okay, so in answer to your question,
So,
perhaps if they had done that, they would have found out maybe mom's not taking the right medication, maybe nobody is keeping track of whether she's taking her medication, maybe we could provide someone who will assist her, or at least be in touch with her to make sure she's taking her medication. Because eventually, it was testified to, or it's in the record, that when mother takes her medication, she does okay.
So I understand your point, and here's, just putting my cards on the table, where I'm struggling. It's no surprise the department has had quite a bit of time knowing what the specific issue is, right? That mental health is the really sole issue here. Maybe not the sole issue, but it's the issue. But when a client isn't going to even the initial treatment, and not taking medication regularly, when they're not even compliant with that basic need? How is it fair then to say, well, then there should have been another evaluation for a person who because of her mental illness, denies having a problem, doesn't go
But there was never, excuse me for interrupting, there was never an evaluation in the first place. DCF did not do their own, at the recommendation of the court clinic, did not do their own investigation as to what meds she's taking, whether she's taking them properly, what can we do to improve her compliance with her medication regimen. Okay? And if you're going to say, well, she just refused to do it, well, that's part of her paranoia and her schizophrenic disorder that enabled her to resist. I mean, this is a woman who was involved with DCF for 20 years, since she was 9 years old. And it's obvious that she is triggered by her contacts with DCF. But DCF didn't do what they were supposed to do. And while this case was still going on, when this case was remanded in July of 2023, okay, now the disability policy at DCF is fully in effect. What did they do? They didn't do a family assessment. They didn't even do an action plan. And they certainly didn't ask her new attorney, because she was pro se before this, didn't ask her new attorney to sit down for an ADA meeting and say, what could we do here? So there was an utter failure in this case. And frankly, it's on page 28 of my brief. There are things that, according to the disability policy, a social worker is supposed to do if he or she observes that a parent has a disability. And I'm not going to read those for you because I'm sure you've read those as well. But if DCF is not going to follow this standard, it may not have the force of law, but it was a voluntary undertaking by DCF to assume these duties. If they're not going to enforce it, and if courts are not going to hold them to that standard, then we might as well just rip it up, because it's only window dressing. It doesn't have any meaning whatsoever. So I'd also like to address, in the few seconds that I have left, the notion of mother's insight. Now, I'll refer you to page 21 of my brief, which talks about the many strengths in DCF's family assessments from, I think it was 2019, 2020, and 2021, all of which listed 6 or 8 or 10 strengths that this mother had with respect to dealing with her child. And if her mental disability, if there's to be some nexus between her mental disability and harm to the child, then look at page 21 of my brief and ask yourself, well, if she's able to do this, then how is it that she's harming the child? Now, I'm not saying that the child wasn't exposed to domestic violence at one point. She wasn't exposed to outbursts by mother at one point. But as of the time of trial, none of that had been re-examined. Not even a family assessment, not even an action plan. I see my time is up. If there are no further questions, I will rest on my briefs. Thank you.
Thank you, Counselor.
Good morning, Your Honors.
Counselor?
Excuse me. My name is Jeremy Thierman. I'm representing the child in this case. And we are asking that the case be remanded, that this court vacate the termination of parental rights and remand it for further proceedings. The child's position, and the child, I would like to say, is turning 11 years old in March and currently residing in a foster home. It's her position that the court did not take into consideration her preference as to permanency.
Didn't take it into consideration at all, or didn't give the weight to it that the child would like it to have had?
I think there's an argument for both, Your Honor. But I think that the kind of superficial treatment in the findings that was given to the child's preference really doesn't provide this court any insight into how the trial court exercised its discretion in that, on that point. So I don't think that that could be considered an adequate consideration and weighing of the evidence one way, or the child's preference one way or the other. Certainly the child wants her preference to carry considerable weight and would like the trial court to consider it. Here, you know, the mere mention of the child's preference and then the court's somewhat conclusory statement in the conclusions of law that they considered it, unfortunately, it doesn't provide any insight for this court to review the lower court's exercise of discretion. And the law is clear that the child's preference is entitled to weight. It is entitled to consideration. And I think the two main cases that I cited help to illustrate how that should work. The Nancy case, I think, would be held out as a gold standard of what is needed for a reviewing court to be able to endorse a trial court's exercise of discretion. In that case, the child's preference was reunification, but the court went through point by point by point explaining what factors they used in deciding that it was not in that child's best interest to be reunified. And the SJC in that case, you know, was able to see the insight and the thought process of the trial court, and so was able to endorse that decision. Our case, I think, is much closer to the Flora decision.
But in Flora, there was no, am I correct that in Flora, the attorney for the child presented nothing about the child's preferences?
That is correct, Your Honor.
Okay, that's a different situation than here, where counsel certainly did present that.
I think it's certainly not 100% on point, but what I would suggest, Your Honor, is that even in a situation where the trial court didn't have the benefit of the child's position, the appellate court was still holding the trial court to the same standard in terms of there still has to be consideration of all of the factors and all of the evidence when considering the child's best interest. In that instance, the child did want to be reunified, and that was only brought up on appeal. And what I think is really instructive about that case is where this court doesn't have a lot of explanation or insight from the trial court, they're going to have to resort to the record. And our record is very similar to that was in Flora. There's not any real explanation as to why the court differed from the child's preference. There was positive evidence that was helpful to the child's preference. That's buried deep in the record. That's not mentioned at all in any of the findings. There are what the child would consider erroneous findings of fact that seem to bolster a case to not follow the child's preference. But I did exactly what I think this court would need to do in that instance and look at those findings of fact and look at the exhibits. When I did that, it was very troubling that the exhibits that were supporting some of these findings of fact really did not seem to line up in any way with the conclusions that the court came to. We would also think it's a error of law for the court to find that this was a forced, this reunification would be a forced removal and apply that standard or apply that factor because it was a voluntary reunification, and so that should not have been applied in that way. Given that I see my time is up, we would ask that you vacate the TPR and remand the case for further proceedings. Thank you.
All right. Thank you, Counselor. And we'll hear from the department now.
May it please the court, Richard Salcedo for the Department of Children and Families. The department is asking this court to affirm the trial court's decision finding mother unfit and terminating her parental rights and approving the department's plan of adoption for the subject child. who is currently 11 and was approximately 3 years old when this case began. Trial court's subsidiary findings of fact, most of which are unchallenged on appeal, show that close attention was paid to the evidence, and those findings taken together clearly and convincingly support the trial court's decisions.
What was the trial court's obligation to fill in the gap of time as far as the information that, to update is what I should say, to update the information that was available to the court by the time of the second trial? Because if I'm understanding correctly, there was about a 2-year gap in services as well as in assessment of information about the family.
I wouldn't say that there was a gap in services. I mean, mother continued to engage in individual therapy, which she had done throughout. She had a medication prescriber who she was still seeing. And there are findings of more recent evidence of mothers, pertaining to mothers' unfitness. In 2023, there are findings about visits. There are issues with visits that took place between mother and the child. There was a relatively recent incident of violence that took place where mother reportedly assaulted a parking garage attendant, which, you know, was a pattern of behavior that was consistent with what mother had engaged in over the course of the case. So while there was not extensive or perhaps some gaps there was evidence that was more recent. And the court...
It's troubling, though, that rescript issues in mid-September and 2.5 months later, we jump into a trial with no court investigator report, sort of no updating, systematic updating of the record. I mean, I don't understand why we didn't have that.
I'm not sure, Your Honor. I can't answer that question. There is substantial evidence, though, in this record that the court based its decision on. The court could properly consider the past evidence of mother's parental neglect of the child and ongoing issues with her inability to regulate her emotions and engage in violent incidents in front of the child.
So we have that, I'm sorry to interrupt, but time is of the essence. We have that past behavior, which certainly the department had quite a bit of evidence of behavior by the mother that would be characteristic of unparental. Okay, but in other words, if in the gap in time in which this case was on appeal, I just want to make sure I'm clear. While I read the record and there were certain times in which the department said, oh, and mom, you know, got into a kerfuffle with the parking attendant and mom did this and mom did that. If mom started going to treatment and mom started taking medication and mom asked for some sort of help, is there any way that that would have been reflected in an assessment and in that information being provided to the judge in making the determination of unfitness?
Well, we have testimony from the social workers, the Department of Social Workers. There's no evidence of mother. There's no request for specific services. She was engaged in services. She was getting her medications prescribed to her. She was engaged in therapy, ongoing therapy. You know, there were times where she improved, but there are many other times where she did not. And I think the other thing that the court really focused on too was mother's testimony, which reflected, you know, there are numerous findings where the court excerpts her testimony and where the court found that her non-responsive and tangential answers were reflective of her continuing poor mental health. So
that, though, to me, strengthens Mom's argument that the department had in place a policy. Nobody else but the department put together this policy. And would you agree with me that Mom seems to fit the description of an individual who would benefit from some services?
I think it's different from, counsel brought up Justice Ditkoff's dissent in Darlene. That case involved a cognitively limited mother. And what was troubling to the trial court and to Justice Ditkoff was that it appeared from the record in that case that that mother was not given. She had serious cognitive limitations, and the record seemed to indicate that appropriate services were not offered to that mother in order to see whether, if provided with services, she could safely parent the child. And that was not done in that case. And the question was whether, perhaps if given the opportunity with supportive services in place, could she parent this particular child? And in this case, mother does not have cognitive limitations, and she was given opportunities to parent this child. There were 4 attempts at reunification. The department was working with mother. There were services in place. The department was assisting her, and mother was unable to provide basic care for this child, including medical care, basic food and hygiene care.
So no question that there were incidents in which the department relied upon as evidence of unfitness, but the question to me is deeper. If the department has a policy that says that child welfare agencies requires to provide parent or caregivers with disabilities an equal opportunity to participate and benefit from all child welfare programs, right? How would we know unless you actually did it? In other words, you put up this policy and recognize that there are certain issues that require, and disabilities that require some special care. And since Mom's been 9 years old, everybody knows that Mom has some deeply ingrained distrust and behavioral issues related to her mental health that has constantly caused evidence of parental unfitness. So are we just to say, limit Justice Ditkoff's dissent to cognitive behavioral issues? In other words, somebody who has a long-standing history of bipolar or schizoaffective disorder, who the department has plenty of evidence of this, are you not obligated by your own policy to do something? And if you don't do anything, is there no remedy?
Well, I think, in this particular case where mother had services in place, I think if mother did not have, access to individual therapy or medication prescriber or psychiatric care or whatever, I think I would agree with Your Honor that, there would be a gap there that the department should step in and try to fill. But this has been a continuing pattern in this case where mother had access to those services. Sometimes she complied with them and, was medication compliant, and she improved at times, but other times she did not. And I think, by the time of trial, I think it might have been a different case if mother was able to demonstrate that she had improved to the point where, she was, had benefited from the services that she was engaged in. But I think the department probably, had worked closely. They knew the mother had been involved in she'd been psychiatrically evaluated numerous times over the course of the case, had been prescribed certain medications over the course of the case. There was one finding where it was recommended that she use a long-lasting injection in order to address her schizoaffective disorder, but she refused it. And the department revisited that recommendation with her some months later, but she again refused it as well.
But isn't that part of the point of the policy, at least as far as I see it, is to say you have this universe that you're living in as the client, and it's not working. So what do you need to make it work? This is what we can help you with. And I understand the argument that there have been services offered, but if they're not doing the trick, so to speak, why isn't the point of the policy exactly to open the door to the potential that there is some other mechanism? Maybe there isn't, but isn't that what the policy requires the department to do?
Perhaps, Your Honor. I'm not sure if, even if the department had, it would have made a difference given the history of the case where mother has been uncooperative with the department, antagonistic towards the department, resistant to, other suggestions or recommendations, feedback, whatever, regarding things that she needed to do. We're talking about a 10-year history of engagement with this mother. In the meantime, the child has been in a pre-adoptive placement continuously with the same pre-adoptive mother, and has been doing extremely well in that placement. And the question is, how long do we wait for mother to improve, where she has demonstrated an inability to provide for this particular child's most basic needs when given the opportunity to parent her. So I think that the court's decisions regarding the child's best interest, termination of parental rights, was well supported by the record. And if there are any other questions, I'll rest on my brief.
All right. Thank you, Counselor. Thank you, all three of you. These are always difficult cases, and we appreciate the briefing and the argument. We're going to take a break now. It will be no longer than 15 minutes, and then we'll come back and hear the last two cases.
All rise, please. Court is now in session. Please be seated.
All right, we're back in session. Thank you for your flexibility.
Thank you, Your Honor.
I'll call the case for the record, 24P 515, Sieber versus members of the Edgartown Conservation Commission. Whenever you're ready, Counselor.
Thank you. May it please the Court. My name is Patrick DiNardo. I represent the appellants in the case, Joseph Sieber and his wife Jody Landau, Brian Carty and his wife Mary Carty. They were butters to a property that's a proposed project for residential development. The issue here, the central issue in the case, relates to the Edgartown Conservation Commission's failure to enforce the language of the bylaw that people of the town of Edgartown chose to enforce and enact. Obviously, the people recognize the unique nature of Martha's Vineyard and the importance and value of protecting views to the water in connection with any development adjacent to the water. The bylaw from the town of Edgartown is clear in its intent, and among the values, it is enacted to protect our natural and historic views and vistas to the water. The Edgartown Concom failed to do its job, and so our clients brought an action in certiorari in the Superior Court and asked the Superior Court to rectify the Edgartown Conservation Commission's lackadaisical approach to enforcing the bylaw that it's charged with enforcing. And so the issue really comes down here to standing. That was a challenge that the appellees made in the Superior Court. It was not a challenge they had raised before that time. And in the Superior Court, we addressed their challenge to standing, which was being raised for the first time, with affidavits. And the law is very clear that to demonstrate standing, the plaintiffs are required to make a showing of a reasonable likelihood that they've suffered injury to a protected legal right. Now, Superior Court looked at the bylaw, and the bylaw is clear and simple in its stated intent to protect views and vistas, natural and historic views and vistas, and he found that the plaintiffs here do have a protected legal right. He then went to the next question in the analysis, which is a question of whether or not there was a reasonable likelihood of an injury being suffered. And he found that the injury alleged here was speculative, but during all our argument, and you can see it from the transcript, he actually focused on the affidavits that our clients put in. And this court has said it's appropriate to review these affidavits when standing's being challenged for the first time. So the two affidavits make it very clear what the views are and how long they've been in existence. They are natural views. They're views to the water of Katama Bay, and they're historic. Both abutters live on or adjacent to a street that's called Katama Bayview Road. I mean, that in and of itself indicates the historic nature of these views. So the affidavits go into great detail about how each house that the abutters live in was either sited or built in such a way to take best advantage of the views, which are obviously very valuable.
So can I ask a question on that topic? Assuming that the views are historic and natural, just assuming for that purpose, I understand your argument that your clients made significant efforts to buy houses that were sited in a way that would allow them to take advantage of those views.
Correct.
But I'm not sure how that, I do practically understand how that's different for them than it is for people who are driving down the street or riding their bikes down the street or whatever it might be. But how does the fact that your clients paid for these views make their harm and the loss of the views different for the purposes of the bylaw than the rest of the public?
Well, obviously there's a financial impact on my clients because the views are important and actually an amenity to the properties they bought. It's the reason they bought those properties. And people want to rent their properties occasionally, specifically because of the view. So there's a financial impact. But every view obviously is a matter of perspective. And so I would submit every view is unique. Every view is specific. In the Siebers case, their views are from the second floor of their house, which was built upside down with the living space on the second floor, where you would most normally find the bedrooms.
Again, understanding that your clients went to lengths to take advantage of the views that were there, but how are those interests protected by the wetlands?
Because the language
Bylaw.
doesn't, the language of the bylaw is not restricted to either public or private views. It's views generally, as long as they're natural views and historic views. And it could be either or. The way it's written is it could be a historic view that's protected, or it could be a natural view. In this instance, it's both. But the fact is, the bylaw is written very clearly to protect views, public and private.
But maybe what I'm missing is, I need to be educated on this, but it seems to me that the intent of the bylaw is to protect the wetlands, and part of that universe of things that it's protecting includes views, but the point isn't to protect the homeowners necessarily in the adjacent area. So
Well,
that's
it
where
is,
I'm having
Your Honor,
trouble with
because
that link.
The bylaw is addressed, it's a wetlands protection bylaw, correct?
Right.
But it's written in such a way, and I've seen this in other towns. Some towns have it and some towns don't. There are water-related qualities that the towns have used the wetland protection bylaws to protect. In this instance, they added views to the list of qualities that they wanted to protect. Recreation's another. Access to the water is denied. The next best thing for people is to have access to the view to the water. And that's an important and unique character of any community. And the communities have decided they want to protect that where they can. And in this instance, the abutters weren't asking the project developer to site the house differently or to reduce the size of the house. What they were doing was saying, there's a view channel that's existed for decades. There's a letter to the Conservation Commission that was written by a fellow named Eric Kaplan, who said that this view has existed for at least 57 years that he's lived there. And so this is a view to the water, which is a very important amenity to that whole community and to the properties who enjoy the view, such as the abutters at stake here. And obviously, the views differ from perspective. For the Siebers, their view is across the property and the view channel that exists from their second floor. For the Cardis, they sited their house on an angle, or their predecessor did. They actually bought the existing house, which is sited on an angle to take best advantage of that view channel. And, Your Honor, if you looked at the aerial view of the property, which is in the record appendix at page 217, you'd get a good sense of the lay of the land. And the applicant's property is a rectangle for the most part. The right side of the rectangle has some natural trees. That's where they're going to site the house. It's a higher part of the property. And then the property slopes down from right to left as you're facing the water. And on that left side of the property, you can see from the aerial view, there's really no vegetation in that area except for grasses.
Is that as a result of, or is there an argument to be made that that's in any way a result of being trimmed or maintained in some way?
Well, there is some indication that those grasses in the meadow there were mown over the years. And obviously the appellee's big argument about whether or not this is a natural view is whether there's been cutting to maintain it or enhance it. I would suggest that enhancing the view is entirely consistent with the bylaw, which is to preserve and protect these existing views.
So,
but
can I ask a question on the flip side?
The photographs show that these views have existed for decades.
Could I ask a question on the flip side? And again, maybe this isn't going to matter, but if your clients, would your clients have an argument to make from their interpretation of the bylaw if the owners of the property allowed the vegetation to grow up in such a way, naturally, in such a way that it blocked the views for your clients? Would they be required then to remove those?
Those meadows, the portion of the property that's open grass, I assume over decades, if it was never mown, some seeds from trees in the area might actually take root and grow. That's not been the case. It's a coastal bank, so it's a particularly harsh environment anyway. So
It's not clear what would grow there. But the DEP suggests that for this kind of coastal bank, for erosion control alone, you should have low shrubs and grasses there. So that's the appropriate plantings that should be there. There's a preliminary landscape in the record, which is at RA 195. It calls for screening. Screening is another way for saying we want to block the view. And so it's not a question of what's going to happen over the next 50 years if a tree seeds take root there. It's a question of someone coming in and eliminating the views. And it's not speculative to suggest that these views are going to be eliminated, because in the Carty's case, the parties brought lengths of wood, 15 and 30 feet high, stood them up across the street, and the photographs of their effort are in Mr. Carty's affidavit. And a 15 and 30 foot high planting there obliterates their view. And there's no point. It's a totally unnecessary situation here. It's the case of someone who paid $10 million for the waterfront lot saying, I'll do whatever I want with it. And, you know, the argument is that my clients are trying to impose a view easement. It's not, it isn't about an easement. It's about enforcing the bylaw. And if there's a quarrel with the bylaw, then it's with the people who enacted it, not the people who have rights under it. And my clients have rights under this bylaw. They have rights to see their views.
What's confusing me
protected
is the bylaw requires the commission to impose the conditions it determines are necessary or desirable for the protection of these interests.
Correct.
In the end, how would you show that it was arbitrary and capricious for the commission to find that the conditions you want aren't desirable?
Well, Your Honor, if you read the transcript of the proceedings before the Conservation Commission, the conservation agent was steering the commission towards a view that the only views that matter are views from the water to the land. And so, acting on that, they suggested changes to the water-facing side of the house. They never once gave any credence to the suggestion that views from the land to the water were equally important. And I say that's arbitrary and capricious given the clear language of the bylaw itself to protect views. It doesn't say views from the water to the land. It says views. And so everyone knows, and we cited a case that this court said common sense dictates that a substantial reason people buy these coastal properties is for the view. The view evokes a visceral response in people. It's a valuable amenity to a property, and that's what this case is about. And it's a completely unnecessary case, because if the landowner would just respect the neighborhood, respect the bylaw, and commit to planting the plants that are appropriate for the coastal zone, which are low shrubs and grasses, there would be no issue. But he completely feels he's unfettered, and that the fact that our clients had the audacity to challenge his project, he's going to plant the highest things he can plant. And when they put the 30-foot poles up, my client was incredulous. We put a 30-foot pole up.
What evidence do you have other than your own client putting a 30-foot pole to say this is what's going to happen, other than just supposition that that they're going to plant the tallest of trees and the highest of boards? I didn't see it in the record. If it's there, please direct me to it.
Your Honor, as I said, there's a preliminary landscape plan in the record. It's at 195. It calls for screening. And as I said, screening is another word for blocking. And so my client didn't just put the pole up. The parties got together and did this together to try to assess the impact.
So can I ask you a question and help me understand this? If it wasn't for this bylaw, what could an abutter do to challenge a home being built that will obstruct their view?
Well, without the bylaw creating a protected legal interest, we would be having a problem trying to block that, of course. But we do have a bylaw which is directed specifically to preserve and protect these
So other than
views.
this particular bylaw, there's nothing that a homeowner could do?
That's right. Absent the bylaw,
That-
we wouldn't
that
have a
blocks it.
protected legal
Right.
right without,
So-
without having paid for a view easement, but
That-
we don't have that.
The difficulty, in my way of thinking, is that the bylaw is about the general public, and it's about protecting the wetlands and the water quality, yet standing has to be individual.
I understand that.
So almost by its very nature, the vehicle that's being used doesn't seem to be the right match.
Bylaws are written in other towns to talk about the views from the public ways. That's not a qualification to the views at issue here. I see my time is up, and I thank you for your attention. I would ask the court to reverse the dismissal and remand with instructions. Thank you.
All right, thank you, Counselor. Whenever you're ready.
Thank you. Good morning, Your Honors. May it please the Court. I'm Kevin O'Flaherty, and I represent the Carps, the property owners who want to build a vacation home on this beautiful piece of property. I want to address two things, the same two things we addressed in our brief, actually, which is first the question of standing and why Judge Gilday got that right. And the second goes to something Justice Ditkoff mentioned, which is even if you assume standing, how is this decision arbitrary, capricious, whimsical? And on a 12b6 sort of standard, they don't even get over that. So number one on standing, Justice Hand, you're quite right, I believe, to put your finger on one of the issues, which is what does this bylaw protect? This bylaw is a wetlands bylaw, as you said, Justice Walsh. It isn't meant to protect the value of Mr. DiNardo's client's property. That's not the purpose and intent of the bylaw, to make sure that people who enjoy a view perpetually enjoy it because they don't have a view easement. And my client's land is registered land over which even prescriptive rights cannot be obtained. The bylaw wasn't created to override those things, and the bylaw wasn't created to allow private parties to use it to get those benefits. The bylaw was created, as Your Honors have noted, to protect wetlands values and arguably the public's interest in those wetlands values. So let me just talk about that for a second in the context of standing. As Mr. DiNardo noted, standing in these cert cases, as the cases teach us, Friedman, Hickey, Your Honor, this court's recent case in Beard v. Earth Removal Commission of Carver, they all say that standing in these cases presents the plaintiffs with a formidable challenge. Formidable because they have to do a couple of things. First thing they have to do is find an interest that's protected by the bylaw. And again, it's our position, Your Honors, that private views are not within the protection of a wetlands, local wetlands
But
bylaw.
why is that? It says natural and historic views and vistas. It says natural and historic views and vistas. It doesn't say public or private.
I understand, Your Honor, but the purpose, I'm just saying the underlying purpose is in favor of the public. And I say this is how the commission itself understood its responsibilities. If Your Honors look at Record Appendix 330, there's a discussion there. It's brief, but there's a discussion between the chair of the commission and my client's engineer at Record Appendix 330, where the chair of the commission says to my client's engineer, so why don't you explain to, I'm paraphrasing, why don't you explain to us how your project is going to protect the public view? Now that is how the commission very reasonably understood its role here, is to protect the public view, Your Honor.
Boy, it's tough if the commission's adding a word that's not in the bylaw for us to accept that.
I understand, but I'm just telling you, Your Honor, that's how I take that interchange, that's what the commission was focused on. And why was it focused on that, Your Honor? It was focused on that because if you look at, for instance, Record Appendix Well, I'll just say there was an exchange, there was testimony by Mr. Sieber as follows. Again, I'll paraphrase. The bylaw doesn't protect the view from my house. It doesn't protect the view from Mr. Carty's house. It protects the public view. Now, it's a little bit hard to understand how a party can come in and tell the commission, here's your job. I'm not saying you got to protect my private view. This is what you have to do. And then later, after they do that, in their discretion, as Your Honor pointed out, they're the ones who determine what conditions are necessary, to say, well, you should have protected the private view when I told you not to. So number two is the parties themselves told the commission in testimony at the hearing, look, what we're here on is the public view.
Well, one did. One party, correct?
Well, but Mr. Carty was sitting there. He didn't jump out of his chair and say, I'm sorry, Joe, you're wrong. It's both things. And in their complaint, Your Honor, if you look at their complaint, which is in the record, they totally equate the view that they're trying to protect with the public's view. Throughout their complaint, they say, the public and we have enjoyed this view. The public and we have had this view for decades, whatever it is. They're not distinguishing it. And this is where Judge Gilday, honestly, this is kind of what he honed in on, because besides finding an interest that's within the protection of the bylaw, and by the way, there's another reason this view is not within the protection of the bylaw, and that is because it's not natural nor historic. There was evidence, and again, the complaint incorporated by reference the hearing before the board. So all that transcript is incorporated by reference into the complaint. Those are allegations of the complaint too, if you will, for purposes of 12b1 and 12b6. And the complaint, and the hearing, there was abundant evidence that there had been cutting over time. I
don't get that. It doesn't say naturally occurring view. It says natural view, which would seem to be a view of nature. Why would that be naturally occurring?
I understand, and if you read the transcript of the hearing, what certainly the commission's agent, Ms. Varkonda, the commission's staff person, Ms. Shemeth, the Carps, I think everybody in the room, honestly, Your Honor, understood that the view they're talking about is something that hasn't been manipulated by people. And if you look
isn't that the problem, that you've come in here and you've told us that the commission added two words to this bylaw, one public and the other naturally occurring? I mean, they can't do that, right? They have to apply the bylaws as was passed by the people of the town, right?
Well, Your Honor, the commission is given the responsibility to interpret their own bylaw. And in fact, this court in administrative decisions that are many will say that where a local municipal commission, a zoning board, a conservation commission, a planning board interprets and applies its own bylaw, that is certainly within its discretion and its job to do so. In this court,
it can't add words to it, can it?
Well, I don't think they added any words. They interpreted it, Your Honor. I agree. There's no words that say public or private except a little above that sentence. They don't describe the views as either public or private, but it's up to the bylaw to make a rational and reasonable application of language, which, you know, Your Honor, is typically always equivocal and hardly ever univocal. So in this particular case, I'd say, yes, there's some lack of clarity here, and I think it's certainly within the province of the commission to do what's reasonable and impose a reasonable interpretation, what they did. But the real issue, Your Honor, is the third problem with standing. And the third problem with standing is this. Even if, Your Honor, you have a protected interest, we say that private views aren't protected. And even if they are natural and historic, we say they're not, because there was abundant evidence both from the commissioners, from my client, and also from the plaintiffs, or the appellants themselves in the affidavit, in which they said that there has been regular cutting and trimming of trees over on my client's property on the south side. Even if all those things don't eliminate their standing. The third requirement for standing is they have to come forward with evidence, real evidence, not just conclusory assertions, not
Right, so
speculation.
why isn't the Carty affidavit, they put up polls, he looked at it, we got pictures of it, why doesn't that establish that it blocks his view?
Those pictures don't speak for themselves, Your Honor, and the Carty affidavit is not competent evidence to explain why those polls represent anything. The fact of the matter is, as Judge Gilday said toward the end of his decision, in these cases, both in the zoning context and in the Conservation Commission context, where a plaintiff has to, as here, not just rest on the allegations, not just fold their arms and say, it's obvious, it's res ipsa loquitur. If you put something there, it will block my view. They have to come with evidence of that.
I don't know why someone's first-person observations from the property in question isn't evidence.
Because the trees aren't there, or the screening isn't there. You know, it's not up to the judge to imagine it. It's not up to the judge to guess at it. It's the burden's on the plaintiff in these cases, Your Honor, to take a photo, for instance, like the photos they had, and then superimpose, which they do all the time in these cases, what, you know, a 6-foot tree looks like, what a 10-foot tree looks like, and the like. That's the kind of evidence that is required, not, I say it must be so, and by the way...
I mean, it sure looks like you can't see the property over this pole, the water over this pole.
Well, Your Honor, you can, actually.
I see the sky.
Here's the point, Your Honor. These properties, the Carty's property and the Siebers even more so, are distant, they're across the road, and they're up the hill. And therefore, Your Honor, the perspective has to be from that house, which is at an elevation higher. And I would suggest to Your Honor that those, even the pictures with those poles, show that you can see the water over the 15-foot or the 30-foot length. There's nothing in those pictures that really conclusively determines that they would block. But let me just give you one more, I think, more important.
So, I mean, that's interesting. Does it have to be conclusive? Is this supposed to be just enough to get to a finder of fact after discovery, or does it have to prove it for sure?
That's right, not beyond.
No, I really meant that as a question. I don't know.
No,
at this stage.
It just has to be, you know, credible evidence, I would call it. But here's why, in the record, there's not even credible evidence of that. One of Your Honors, I think it was you, Justice Walsh, asked the question of where in the record appendix is there evidence that they're going to put up 30-foot trees or 15-foot trees or whatever. There isn't anything. If you look at the landscape plan, RA 195, they have a legend there. I know it's very small. You'll have to blow it up. But they have a legend on that RA 195, which is to the left, that talks about the kinds of plantings they propose. In the front of the property, along the frontage, it's ornamental gardens. The highest, if you look at that legend, the tallest shrub or tree that they propose is 6 to 7 feet tall.
But that's not something, I take it, that your client is willing to commit to at this point.
What they have, Your Honor, is an approved landscape plan that says that. And that's what they intend to plant. But the question is, do they have to then in perpetuity keep cutting and trimming and make sure? And I suggest to Your Honor, there is nothing in the law or the bylaw which would require that. One of Your Honors asked the question, what happens if they do nothing? There was a Conservation Commission member, her name was Provence. She went out and took a look, and it's in the record, it's in the hearing, and she said, yeah, I went out and I saw the evidence that this view has been created by cutting and trimming, because the north half of my client's property is fully treed and wooded, thick. You can see it in the aerials of the property. It's the south half which has been cut and trimmed. And what Commissioner Provence said when she went out and took a look for herself, and the other commissioners did the same thing, was, I noticed that at the front there's all this bayberry. Obviously that stuff grows like weeds, and if that hadn't been cut and trimmed regularly, it would be very, very tall. And there is nothing in the bylaw, as Your Honor asked, that would require my clients to maintain a certain height on their property. They could just let if nature was left to take its course, if the natural world were to prevail here, this would be a very, very heavily wooded and treed site. And that was the evidence in front of the commission, and they're entitled to rely on that. And that gets to my last point as my time's running out, which is, Justice Ditkoff, you talked about sort of a failure to state a claim. How could they ever show on the record, which includes, because they added it to their complaint, which includes the testimony and the whole hearing transcript, how could they ever show that what the board did here was arbitrary and capricious? And I would say they can't, because there was evidence upon which a reasonable board could determine that that condition that they asked for, basically a perpetual view easement over my client's registered land, wasn't necessary or appropriate. So, Your Honor, for all those reasons, I would ask that the Judge Gilday's decision be affirmed, and I thank you for your attention. If you have any other questions, I'll try to go at them, but I see the red light blinking.
Yeah, no, thank you both.
Thank you, Your Honor.
It's a tricky case, and we're very appreciative of both the argument and the briefing.
Thank you, Your Honor.
You can come forward. We'll let them leave before we start, but you can come forward. Take your time. No rush. All right, so before we start, first I have to call the case number 24P678LF versus E.K.F. And before we start your time, I just want to make clear, under federal law, we have to be careful here not to mention any names. We can't mention your name or the plaintiff's name, and so we'll just use wife, husband, plaintiff, defendant, and we certainly don't want to mention the names of any of the children, since this is being live streamed. So just be careful not to use names, use descriptions, oldest child, wife, husband, or you can say I, but don't use your name, right? So with that said, whenever you're ready, you'll have 15 minutes. The clock will hit yellow when there's 90 seconds left and red when the time's up.
Okay. Thank you, Your Honor. I am the appellant and defendant in this case, and I would like to start by thanking this honorable court for the opportunity given to present this case. So the issues of laws of this case are: did the lower court err in renewing the restraining order against me, despite finding that the appellee was not in fear of imminent harm? Was the renewal based on improper ground, including past abuse or ongoing nature of the conflict, rather than a statutory requirement of the law? Did the lower court fail to apply consistent legal standard, and by doing so, prejudicing the appellant? The fact of this case are simple. The parties are a married couple with 4 children. in February 2021. Mutual no restraining orders were issued by the lower court, recognizing that both parties had acted abusively against one another. In April 2021, the appellee alleged to the police that the appellant had violated the restraining order and assaulted her. On April 5th, 2021, during the arraignment, the lower court dismissed the charge of assault and battery on a family member after reviewing the recording of the incident. On April 6th, the appellee filed for divorce, and between July 2021 and August 2022, the appellee filed 4 criminal complaints against me. All were dismissed. And in February 2023, I was found not guilty of violation of a restraining order after a trial at the Woburn District Court. On February 2022, the lower court renewed the restraining order against me for 2 years and renewed the restraining order against the appellee for 1 year. On February 15, 2023, the appellee used the restraining order from the Woburn District Court to make misrepresentation in the probate and family court in order to gain advantage in the divorce proceeding. And for that reason, she was harshly reprimanded. And the probate and family court found on several occasions that the appellee was not credible. She also used the restraining order to gain advantage in the divorce proceeding in multiple occasions. In one occasion, she used the restraining order to try to compel the appellant to agree to a unilateral refinancing of the marital home, threatening to go after the appellant and his attorneys if the appellant did not agree. After the first judge of the divorce proceeding recused herself in the probate and family court, the appellee used the restraining order in the district court to try to gain full physical and legal custody of the parties' children.
Can I ask you a question about the divorce case?
Sure.
I knew there was a trial scheduled in October. Did that happen?
The trial has now been completed. There were 3 days of trial, September 16, 17, and October 29.
And has there been a decision? Are you waiting for a decision?
We are still waiting for a decision.
All right. Thank you. That's really helpful. I couldn't tell from the computer.
So, after all these attempts to gain all the advantage that she could in divorce proceeding failed, the appellee continued to use the restraining order to gain all the advantage, including making misrepresentation to the parties, in order for the school authorities to prevent the appellant from participating in the children's education. After a hearing on February and March 2024, the district court acknowledged that the appellee was not in fear of imminent harm by the appellant. That finding was made. However, the court nonetheless decided to renew the restraining order, citing the ongoing conflict between the parties and past abuses. I submit before the court that renewing the restraining order was improper for various reasons. First, the appellee did not meet the standard for a renewal, and the lower court correctly made that finding. The standard being to prove that the appellee was in fear of imminent harm. The second reason is that the renewal was based on past abuses and ongoing conflict between the parties. However, the past abuse and the ongoing conflict between the parties can both be attributed to both parties, not one party only. So the fact that this is used to renew the restraining order against one party only is prejudiciable. And regardless, past abuse and the ongoing conflict of a relationship are invalid ground to renew a restraining order under the Massachusetts law. The third reason is that the restraining order has been consistently used as a tactical tool in the divorce proceeding on several occasions, as documented by the record appendix. The court also, and this is the fourth reason, the court inconsistently applied the legal standard by not renewing the restraining order against the appellee when it was up for renewal. So by renewing the restraining order against one party for past abuse and conflict between the parties and not renewing the similar restraining order against the party, the court prejudiced the appellant, and I ask this honorable court to correct this miscarriage of justice. So regarding the lack of imminent fear of harm, the court acknowledged that the appellee did not have the reasonable fear of imminent and serious harm. And in fact, the lower court said, is there a reasonable fear of serious and imminent physical harm? I can't say I can find the plaintiff met that standard of a reasonable fear of serious and imminent harm. This was a finding by the lower court. The Massachusetts law requires a showing of imminent harm for both initial and renewal restraining orders. There are cases of law that specifically make that requirement, several of which are cited in the appellant brief. The standard for obtaining an extension of an abuse prevention order is the same as for an initial order. Most commonly, the plaintiff will need to show a reasonable fear of imminent, serious physical harm at the time that the relief is sought. No presumption arises from initial order. It is the plaintiff's burden to establish that the fact that exists at the time of the extension of the order is how to justify the relief. As we know, the evidence shows that not only did the appellee isn't in fear of imminent harm, but in reality, she is the one prone to using abusive language against the appellant and the appellant counsel. The evidence presented at the lower court shows that in February 2022, the appellee on several occasions actually drove to the apartment of the appellant. She took pictures of the appellant vehicle and sent those pictures to the appellant counsel. This shows that she definitely wasn't in fear of imminent harm. The second point, the improper basis for the renewal. The court based the renewal on past abuse and ongoing conflict. Quoting from the lower court, The other standard is whether the plaintiff has suffered abuse and still suffering from the effect of that abuse. I find this to be clearly the case. So this clarified that the court renewed it based on past abuse. And it is the my whole point that past abuse existed on both parties. However, the court only used this past abuse and the conflicting nature of the parties' relationship to renew the restraining order on one side. And similarly, there are several law cases here that specifically require that no restraining order should be renewed solely based on past abuse. And in fact, case law reads, therefore, we conclude that the 209 focuses on preventing imminent serious physical harm, not merely responding to past abuses. And it goes further in citing generalized apprehension, nervousness, feeling aggravated or hassled, psychological distress from vexing but non-physical intercourse when there is no threat of imminent physical harm does not rise to the level of fear of imminent serious physical harm. The reliance exclusively on past events contradicts this established legal standard. The third point, the use of restraining order as a tactical tool. The appellee use of the restraining order as a tactical tool is demonstrated in several of her own actions. She has clearly expressed in her own words by threatening to seek criminal charges against the appellant and his attorneys for violation of restraining orders. She has also used the same restraining order to file criminal complaint against the appellant on 4 different occasions, all of which were denied. That show a specific intent to use the restraining order as a tactical tool. The last point, the contradictory finding and unjust application. At the renewal hearing on February 8, the court did not renew at the renewal hearing on February 8, 2023, the court did not renew the restraining order against the appellee despite acknowledging past abuse. So this is a direct contradiction. And this inconsistency prejudiced the appellant in this case. The renewal of the restraining order against me should be vacated for the following reason. The legal standard of imminent fear of serious physical harm was not met. The renewal was improperly based on past abuse and ongoing conflict. The restraining order is being misused as a tactical tool in a divorce proceeding, and the court decision is inconsistent and unjustly applied. The appellate court should vacate the renewal of the restraining order to rectify these legal and procedural errors. Thank you, Your Honor.
Wow, 15 minutes exactly. Our attorneys don't usually hit it that accurately. Thank you very much for your presentation. That concludes the cases for today. I'd like to thank our court officers. I'd like to thank our timekeeper, the clerk's office that always allows us to do this, and of course everyone who argued in front of us today. And with all that being said, we stand adjourned until tomorrow at 9:30 a.m.
Court all rise, please.